Hi friends, welcome to the channel. This is your Govindraj. This video I'm going to give you a brief update about this recent Apex Court judgment on the higher pension under employees pension scheme 1995. But before that friends, in the last two videos I also talked about this managing labor relations, my book, and this book is actually about labor relations at workplace. And let me tell you also friends, the managing labor relations at your workplace is an art, and that art is articulated in this book. And in case you would like to have a copy of this book, you can send me your details. I will be happy to dispatch this book. Friends, now let me also give you the update on this Apex Court judgment, and I'm sure you are reading the flash news on this recent judgment, and also you are trying to understand more about it. But before that friends, we need to know a few preliminary information so that you can follow the judgment. And I have already made two videos on the pension topic, and also the earlier Honourable High Court Kerala High Court judgment, which is also the contention in this judgment. And if you want to understand the topic and follow, it is better that you watch those videos as well for better clarity. The EPF and Miscellaneous Provisions Act 1952 originally did not give any provision for a pension scheme, but the amendment in the year 1995 gave a scope for the formation of the scheme. And Section 6A of the EPF and Miscellaneous Provisions Act 1952, which was substituted in the year 1995, actually gave a power to the central government to roll out this employees pension scheme. Accordingly, the central government framed the EPS scheme 1995, which came into force on 16/11/1995. Originally, it applied to all employees who are covered under the EPF and Miscellaneous Provisions Act 1952, and there are detailed guidelines were prescribed for the calculation of pensionable service and pensionable salary. And the formula for the calculation of pension is a pensionable salary multiplied by pensionable service divided by 70. And of course, there are a few more riders which I will not get into the details in this video. In case you want to know more about it, you have to watch my previous videos. When this scheme was rolled out, the maximum pensionable salary was 5,000 rupees, and later it was enhanced to 6,500 rupees. And again on 16th March 1996, a proviso was added to paragraph 11(3) of the scheme, by which an option was given to employer and employee to contribute on full salary irrespective of the ceiling. And the employees who have not opted for this option took the plea before the Supreme Court that they were not aware of this option, and therefore they should be given the benefit of contributing to EPS at their actual salary. This plea was negated by Provident Fund authorities, stating that there was a cut-off date. As claimed by the EPFO, the cut-off date is the date of commencement of the scheme or from the date the salary exceeded 6,500 rupees. You can see the earlier provision and under paragraph 11(3), and you will definitely be able to understand it. And of course, this case was travelled to Honourable Apex Court in R.C. Gupta and others versus Regional Provident Fund Commissioner, Employees Provident Fund Organization and others in Civil Appeal numbers 10013 to 10014 of 2016. And the Apex Court in this case held that the said dates are not cut-off dates. That means whatever the EPFO was claiming that these are the dates, they are not the dates to determine the eligibility of the employer or employee to indicate their option under the proviso to class or the paragraph 11(3) of the pension scheme. Rather, they are the dates for calculation of pensionable salary. So therefore, the court allowed the plea of the employees and directed the EPFO to reconcile the accounts and granted the benefits. Meanwhile, friends, another set of cases are the EPFO has brought important amendments to the scheme of EPS scheme by notification GSR 609E on 22 August 2014, which actually came into effect from 1/9/2014. And this notification deleted the proviso to paragraph 1113, which actually provided the option for employees to contribute at actual wages. But this notification also added another paragraph, which is 11.4, to the scheme and mandated the exercise of a fresh option jointly by the employer and employee to continue the contribution on higher wages for those who are already contributing it. And the 6 months window was given to exercise this option from 1/9/2014. And there were, of course, other amendments also in this notification. I am not getting into the details, but I suggest you to watch my videos, previous videos on these amendments, and you will be able to definitely connect and correlate these provisions. And this notification was again challenged before the Honourable Kerala High Court by one Mr. Sunil Kumar B and others, and also in Rajasthan and Delhi High Courts similar challenge was also made. And the division bench of Kerala High Court actually set aside the Employees Pension Amendment Scheme 2014, which was conceived in GSR 609E, and upholding the plea of employees. And these cases are now travelled to Honourable Supreme Court, and the Apex Court initially, the SLP by the EPFO, the special leave petition by the EPFO was dismissed by the Supreme Court, but the EPFO again appealed against the dismissal and also filed a review petition. And this review petition was now allowed, and the earlier order was recalled and heard. Now, friends, having this given you the brief, let me give you the gist of the directions or the Apex Court judgment. And first of all, the court held that the notification number GSR 609E dated 22nd August 2014 is legal and valid, considering the provisions and power provided to the government under the Act. And these amendments are also applicable to exempted establishments. And the employees who exercised their option under earlier 11.3 and continued in the service after 1/9/2014 are guided by the amended provisions under paragraph 11.4. The case of employees whose salary contribution was more than the ceiling, that is 6,500 or 15K as applicable, and also who are members of the fund before 1/9/2014 but did not exercise their option as per earlier paragraph 11.4 or earlier paragraph 11.3 of EPS, was also dealt in this judgment. And as per the amended paragraph 11.4, those who exercised the option under earlier paragraph 11.3 and continue to be members were required again a fresh option within 6 months from 1/9/2014 because of 609E. But the provisions in paragraph 11.3 did not construe as cutoff dates as per R.C. Gupta case, which was upheld in this judgment. So therefore, friends, in the current judgment, the Apex Court has provided an opportunity to those who did not exercise the option under paragraph 11.3 to do it again within 4 months from the date of judgment. And you can read subparagraph 4 of paragraph 44 for the directions of the judgment, and definitely you will understand this. The employees who retired prior to 1/9/2014 without exercising the option under earlier paragraph 11.3 are not entitled to the benefit of this judgment, but for those who retired prior to 1/9/2014 after exercising the option under earlier 11.3, the benefit before the amendment is confirmed. The 2014 amendment also made a contribution of 1.16% of the salary beyond 15K in the hands of the employees. This is held to be illegal because there is no provision in the law for this. The contribution of 1.16% of the salary is actually from the government and not from the employer or employee. However, this part of the judgment was kept on suspension for 6 months so that the government can make adjustment to manage the funds through legitimate avenues or amendments to the law. The judgment benefits employees who are members of the fund prior to 1/9/2014, that too whose salary for the contribution for PF and EPS is more than the wage ceiling. And let me also tell you friends, as per the news, the Labour Ministry will come up with detailed guidelines for employers and employees for implementing the judgment, including how we can exercise a joint option to avail the benefit of the judgment. And if you are eligible under this judgment, make sure that you avail the benefit within 4 months, otherwise you may not get another chance. Thank you for watching this video friends. I will leave the relevant citation and links in the description box for you to make more study on this. Let me also tell you friends that it is difficult to narrate all the information of this judgment in the short video. Therefore, I suggest you to read the judgment in details for more understanding. In case you want to talk to me, I've already left my contacts in the description box. You can reach me as well. And see you soon in the next video friends.